Welcome to The Explainer. Today, we're diving into one single question. A question that honestly stops so many people in Scotland from getting the compensation they deserve after an accident. It's that little voice in your head, the one that wants to blame yourself, and it could be costing you thousands. So, let's just get right to it. It's that nagging thought, isn't it? The one that plants a seed of doubt and makes you think, nah, I can't claim for this. But here's the thing. What if that entire belief is just wrong? What if it's based on a total misunderstanding of how the law actually works? I mean, look at these. Not wearing a seatbelt, walking on a floor you knew was wet. Maybe you weren't using the safety gear at work exactly by the book. Do any of these ring a bell? If you've had one of these thoughts after getting hurt, chances are you've already told yourself, well, that's it for me. Making a claim is impossible. But stick with me, because we're going to show you exactly why that conclusion is almost always flat out wrong. Okay, so first up, let's just demolish the biggest and, honestly, the most expensive myth floating around in Scottish personal injury law. If you take away only one thing today, make it this. The law does not expect you to be perfect. Seriously, Scottish law is built for the real world. And in the real world, accidents are messy. They're complicated. Oftentimes, more than one person plays a part. So let me say it again. You absolutely, positively do not need to be 100% blameless to get compensation.
So you might be wondering, how did the law get so reasonable? Well, to get that, we've got to take a quick trip back in time to a pivotal moment that basically changed everything and made the whole system a lot more fair. And this timeline really spells it out. Before 1945, the law was, well, it was brutal. Imagine this. If a court decided you were even 1% at fault for what happened, you got zero, nothing. It was a completely all-or-nothing game. But then in 1945, this new act came along and just threw that whole unfair system right out the window. I mean, look at the difference here. It's night and day, right? The old way, one tiny slip-up and your entire claim was gone. Poof. But the rule we have now, it's totally different. Your compensation just gets reduced by a percentage that matches your share of the blame. The key thing is your claim is still very much alive and kicking.
And there it is, the official legal name for it. Contributory negligence. Don't let the fancy words throw you off. The only words that really matter here are reduced and share. It's not about killing your claim, it's about fairly splitting up the responsibility, which is a whole different ballgame. Let's make this super simple. So this chart shows a pretty common scenario. A court looks at everything and says, okay, you were about 25% responsible. Back in the old days, that meant you walked away with zilch. But now, you don't lose the whole thing. Nope. You still get the other 75% of the compensation.
Right, but how do they even come up with a number like 25%? It's not like they just pull it out of a hat. There's actually a really logical two-part test they use to figure it all out fairly. Okay, so step one is something called causative potency. All that really means is how much did what each person did actually cause the injury? A dangerous driver's actions are a huge cause, right? Then, step two is blameworthiness. This is about how bad was the behavior. Speeding through a school zone is way more blameworthy than just a brief lapse in concentration. The court weighs both of these things up to get a complete and fair picture. All right, enough with the legal theory. Let's talk about the real world. How does this stuff actually work in situations you could easily find yourself in? Seatbelt cases are probably the classic example, and the courts in Scotland have a really consistent way of handling them. Just look at this table. Even in the absolute worst-case scenario, where wearing a seatbelt would have stopped you from getting hurt at all, the reduction is almost always just 25%. It never wipes out your claim completely. So let's use some real numbers to see just how big a deal this is. Imagine your claim, if the other person was totally at fault, is valued at £100,000. Okay, so now let's factor in that maximum 25% reduction because you weren't wearing a seatbelt. At this point, that little voice in your head is probably screaming, "See, I knew it, it's all ruined." But hold on, look at that number. You would still walk away with £75,000. That's a truly life-changing amount of money that you would have gotten none of, all because you assumed you couldn't make a claim in the first place. And it's not just car accidents. When it comes to accidents at work, the courts are pretty savvy. They know how things really operate. They don't just look at you and say, "Did you follow the rule book?" No, they dig deeper. They ask things like, "Did your boss actually care about safety rules? Or was it just a poster on the wall?"
Was it even possible to do the job safely with the time and tools you had? You see, they get that often the real fault lies with the company's system, not with you.
Same goes for slips and trips. The whole thing boils down to one word: reasonable. The law expects you to be a reasonably careful person, not some kind of superhero scanning for threats. You should be able to walk through a public place without having to analyze every single floor tile for a potential hazard. There's a big difference between carelessly walking while staring at your phone and slipping on a wet patch that nobody bothered to signpost. So, this all leads us to what is, without a doubt, the single most important point I want you to take away from all of this. And honestly, it's more of a warning than anything else. Here's why you should never, ever try to be the judge in your own case. Think about it. The insurance company on the other side, their entire job, their whole reason for existing is to pay you as little money as possible. They will absolutely seize on your own feelings of guilt, your own doubt, and use it as a weapon against you, to slash the value of your claim. It's what they do. So let's bring it all home. The bottom line is this: being partly at fault just reduces your compensation. It does not, and I'll say it again, it does not get rid of it. Even if you were somehow 50% to blame, that still means you are entitled to the other 50% of the compensation. That's the law. So that feeling you have, that little voice saying it was partly my fault, that isn't the end of the road. Legally speaking, it's actually just the starting point of a calculation. So the real question is, are you ready to stop guessing and find out what your claim is really worth? Because the only way to do that is to get expert advice. It's the only way to truly know.